of the jury. In light of the expert testimony of the psychiatrist, it is clear that my client is suffering from schizophrenia and was in no way responsible for the crime he committed. He needs a mental hospital, not a prison.
As prosecuting attorney, I have gathered expert psychiatric opinion to show the defendant was totally sane when the crime was committed. He should be punished to the full extent of the law.
What is the correct role of the psychiatrist in the courtroom or in the prison? Should a psychiatrist color legal testimony with his expertise, or should the psychiatrist defend the criminal as a victim of external forces? And what should be the convicted man's fate? Psychiatry and law. How are they related?
I am Dr. Thomas Szasz. It is my view that the use of psychiatry in the criminal law subverts and contaminates the judicial process and degrades and dehumanizes the individual accused or convicted of an offense.
I am Dr. Bernard L. Diamond. It is my position that psychiatry and the other behavioral sciences have much assistance to offer to all phases of the administration of the criminal justice system.
I am Alex Brooks. As a professor of law, dealing mainly with the problems of the criminal justice system, I am concerned with the proper and effective role of the psychiatrist, if any, in the criminal process. As moderator of this program, I will try to focus attention on the issues that are raised between two extremes that are represented by Drs. Diamond and Szasz, and try to structure the discussion so that we can understand what the real problems in this field are.
Welcome to the exploration of concepts and controversies in modern medicine, one of a series of programs dedicated to examining the uncertain, candidly recognizing that much of today's teaching is necessarily based upon opinion, and that the opinions of eminent physicians in a given field vary widely. The National Medical Audiovisual Center believes that openly airing such opposing views is a basic responsibility of medical communications. Professor Alexander D. Brooks, Rutgers University Law School, will act as moderator of this presentation.
Now, Tom, you've started out in what those of you who know you have come to regard as a characteristically provocative way by talking about the role of psychiatrists who think of themselves as healers and helpers, humanitarians, and who are so regarded generally by the public as contaminating and subverting and degrading and dehumanizing. Now, this seems like a very harsh indictment of the role of the psychiatric profession in the criminal law, and I wonder if you could spell out what you have in mind.
Well, I will try, Alex. Really, my view is rather simple in this respect. My point of departure is that the law, the criminal law, is essentially a system of social controls. Every society must have an articulation of what is acceptable and desirable behavior and what is unacceptable and prohibited behavior. And in modern Western free societies, the way to deal with prohibited behavior is through the criminal law, through its sanctions and through its procedures, which give a great deal of protection to individuals accused of crime in order to prevent innocent persons from being punished. Now, psychiatry comes into this process through the false representation that it is a medical science. when in fact it is my view that it's neither medical nor in its courtroom use scientific. In its courtroom use, psychiatry is a strategic intervention to achieve certain policy or social objectives, and more particularly because of its consequences, which can be involuntary incarceration, that is a form of imprisonment, through psychiatric auspices. It is in fact an ancillary to the social control system, to the legal system, the penal system. An illustration of this would be, and in other words, because of its consequences, not because of its aims, but because of its consequences, it is dehumanizing in the law. It is my general view that whenever psychiatry is used against the will of the individual upon whom it is used, it is antagonistic to him and not to his benefit. Perhaps the simplest example I can give of this general contention is the phenomenon which affects thousands of people throughout the country, of individuals being accused of crime, apprehended and accused of crime, but not tried, but instead of trial being declared unfit to stand trial, even though they may verbally, quite clearly express a wish to be tried. They may have a lawyer who is quite willing to defend them, but nevertheless they may be declared unfit to stand trial by the judge and incarcerated in institutions called mental hospitals for years, often for life.
Now, Bernie, I take it that you take issue with Tom on these points and that you probably have points of your own to make.
Yes, Alex. I certainly agree that the primary function of the criminal law is to exert social control. But the criminal law has developed in a very complex way as a result of hundreds of years of tradition, plus certain kinds of democratic principles. And in enforcing the criminal law, it's very important that full consideration be given to a number of factors. In the first place, the criminal law does not punish or control people exclusively for their deeds alone. A deed is rarely a crime under the criminal law. For the criminal law to reach the decision that certain people should be punished or controlled or deprived of liberty, there has to be a consideration not only of the act that the offender has done, but also a consideration of what is called his mental state. In other words, a consideration of his motivations, of the psychological factors which caused him to produce the criminal act, and particularly what the law calls criminal intent. Now, the law traditionally, and I think quite correctly, excludes certain classes of individuals from punishment. Certain classes such as children, the insane, people who are unable to comprehend their responsibility to the prevalence of morality of society are sometimes excluded. Now, in a criminal trial, a whole series of very vital decisions have to be made by the judge and by the jury. And even after these preliminary decisions concerning guilt are made, then there are additional decisions concerned with sentencing and eventual release and restoration back to society of the offender. Now, it is my position that although in ancient times the law made these decisions exclusively on the basis of well-known common sense principles of psychology and a rather oversimplified view of what the human mind is like, I believe that modern behavioral science, psychology and psychiatry, has a great deal of additional information which they can provide to the law, which will assist the law to make these very difficult decisions. It is not my contention at all that psychiatrists or any other experts should usurp or take over the decision-making processes of the law. It is simply that the law is and should be even more receptive to the use of what I insist is reasonably scientific information in ways which helps them to make traditional decisions, which at best are very, very difficult to make.
Well, then, it seems to me that your view that psychiatry has an appropriate function in the criminal law rests on the notion that there is a body of expertise, that psychiatrists do have a contribution to make over and beyond what the ordinary lay person perceives as being states of mind and the like that are relevant to determining what the punishment should be, or what kind of treatment there should be, or whether the person in fact is guilty or not guilty of a particular offense. Now perhaps, Tom, you take issue with this notion that Bernie states that there is a body of expertise, that psychiatrists do know more than the average person, and that the jury ought to hear what the psychiatrist has to say. Why not?
Well, it is my view that psychiatrists certainly know more about how to do psychotherapy or psychoanalysis than lay people. But when it comes to their courtroom behavior, it is my view, and this is illustrated by the battle of the experts, that essentially psychiatrists are for hire. Their participation is moral. Again, let me illustrate this historically. Psychiatrists themselves, this is not my view, psychiatrists themselves have been very proud and vocal in saying that they have declared defendants insane in order to save them from the death penalty. This has been one of the traditional claims which they themselves have made. Now, this is not a scientific statement. This is a moral justification. This may be morally very nice, but it's nothing to do with science.
Well, I think it can be related to science. I, for one, would quite be prepared to state that I have testified in courts with the hopes of saving a particular defendant from the gas chamber, simply because I believe that I had quite accurate scientific information about the offender's state of mind at the time of the killing, which is directly relevant to the issue of whether or not this man is legally liable to the death penalty. And when what I insist is reasonably accurate and scientific information is presented to the trier of fact, then in some instances the trier of fact is able to see that this man no longer meets the legal requirement for the death penalty.
Have you ever testified that he should be put to death?
No, I am quite unwilling to play both sides of the fence here.
That's my point, but you say it's scientific.
Well,
a toxicologist, if he examines body fluid, sometimes finds arsenic and sometimes he doesn't.
No, I have never falsely testified.
That wasn't my point. It doesn't have to do with facts. It has to do with moral judgments. You testify in accordance with your moral belief that people shouldn't be put to death. That's a very respectable view, but it's not a scientific view. It's a moral view.
But that isn't what I testify to. I testify as to certain kinds of information which I have been able to obtain from the defendant. And if I'm not able to obtain this information from the defendant, then I don't testify.
But you are making an arbitrary distinction between the content of your testimony and the consequences and its aims, the aims towards which you are striving.
Well, in a sense, the jury is responsible for making the factual judgment, and even if you have two psychiatrists testifying on opposite sides of the fence, the jury then evaluates the testimony of either psychiatrist and makes a judgment in terms of its own finding of fact, its own moral judgments. What's wrong about that? Why shouldn't there be this battle of experts? Is there anything that's distortive about it?
I am all for that. I am all for that, because what happens when there is a battle of experts? It's like a battle of advertisers. It's advertising. One says buy Ivory soap, the other one says buy Palmolive. And what the jury does is throw it out. So the whole thing is no good, which it isn't.
That may occur, but that isn't a necessary consequence of the judicial process.
That is that is a consequence unless the defendant is so degraded that he cannot have representation.
It doesn't have to happen that way. The battle of experts is largely a product of the fact that only very, very borderline controversial cases come to criminal trial. The great majority of criminal events, shall we say, are settled by the law on some other basis in a criminal trial. Maybe 90% of all criminal offenders are dealt with by the law on some other way than a criminal trial. Now, those cases which are very difficult to decide, those cases which raise very difficult borderline issues which are not easily resolvable, are the ones that come to trial. And it is precisely that kind of case which requires the full exploration of every conceivable source of information about the defendant, so that the trier of fact, the judge and the jury, can consider all the various possibilities. Now, obviously, a person who is a marginal case exists in a situation in which one could bring out this element which would prove his sanity and that element which would tend to assert his insanity. And this leads, I think, quite correctly to the presentation of diverse, again, which I have to insist are scientific, bits of information, that is, observations about this defendant, which should be taken into consideration by the trier of fact.
Bernie, it seems to me that while we've focused so far on the insanity defense and criminal prosecutions, that in fact, by reason of the lack of very many insanity cases, that the insanity defense and the role of the psychiatrist in the criminal process is really important to people and fascinating to them and of great concern in the criminal justice system by reason of the symbolic importance rather than the fact that there's a large volume of such cases. And the symbolism of it is this: are criminal acts the product of mental illness? Does the psychiatrist have an appropriate role in defining crime and in classifying and characterizing offenders? And then further, once it's determined that the offender is guilty of some offense, a treatment program, whether in a mental hospital or in a prison, is determined, and the psychiatrist perhaps plays some role in that. The psychiatrist apparently has a tremendously important role in determining how long the offender will remain in a hospital or remain in prison, particularly where we have development of indeterminate sentences in which there's a large range of time, and with a great deal of discretion given to boards and bodies in which psychiatrists serve and which psychiatrists are asked to report to. So in fact, I don't think we need to get too involved in the insanity defense itself, but rather, more importantly, we should be talking about the role of the psychiatrist in the entire process. Now, do you stick to your notion, Tom, if we look at it in this very broad sense that the psychiatrist degrades and dehumanizes and contaminates the whole process, when in fact we think that the role of the psychiatrist is intended to mitigate the harshness of the criminal law and to heal people who offend?
Yes, thank you, Alex. That moves us along in a very important direction. Especially in situations where the psychiatrist, for example, determines the length of a sentence or incarceration. That to me is an excellent example of dehumanization, degradation. It is to me the quintessence of a humane, dignified system of social sanctions, that the sanction, that the offense be clearly defined, the rule of law, and that the duration, the quality, the nature of the sanction also be clearly defined. In other words, if someone is sentenced to 5 years in prison, to me that means that after 5 years he has a right to come out, even though he is mentally not changed. So that I would, as you know, I have in my writings analogized involuntary psychiatric intervention, for example, in a prison, to involuntary religious intervention. If a Jewish prisoner goes to prison for 5 years, it's not a condition of his being released, let's say in a Christian country, that he come out a Christian, or vice versa.
In other words,
this is the kind of brainwashing, which is not part of the sentence.
The right of an offender not to
change.
Be compelled to change his
Not
personality, and presumably the psychiatrist is trying to change his personality. Now, the situation is described as one of helping him to change, to conform, but in fact, certain changes are being perhaps imposed on him. That's Tom's view. What's your...
Yeah, well, Tom has described here a view of the criminal law, which I think that many people would find compatible with their own desires. I don't think, however, that it is the correct view of the criminal law, nor do I think it has been the historical position which the criminal law takes in a democratic society. The idea that crimes can be purchased by a given penalty, that if an individual wishes to commit a robbery, as long as he is willing to pay the price of so many years in prison, then he can commit this robbery, and when he's paid the price, he can go out and commit another robbery, and so forth. That is a really, I regard a quite peculiar concept of crime and punishment. The criminal law is primarily, as you stated earlier, a system of social controls. And it's to stop the commission of crimes. And I believe that society has the right to do whatever is necessary in order to stop people from committing crime, providing the constitutional safeguards and civil liberties and the general principles of a democratic society are in operation. This means that the criminal law has a perfect right to retain people as long as is necessary in order to prevent them from committing crimes, providing the decision-making process for their retention is subject to all the constitutional safeguards which are guaranteed to all citizens of a democracy. Now, I certainly do not want to give a kind of a general support for psychiatric testimony in the courtroom. I'm perfectly aware that there have been many circumstances where psychiatric testimony has been used in a very unconstitutional, undemocratic fashion. I'm perfectly aware of the many situations in which the decision makers of the criminal law have defaulted their right and obligation to make the decisions and accept blindly the unreasoned testimony of so-called experts. But because there are many defects in the system of the use of psychiatry in the criminal law, does not, in my opinion, justify throwing out the whole institution. Because I think in general, despite these rather glaring examples of the misuse of psychiatric testimony, I think in general psychiatry has been a very, very helpful in two specific ways. One, as in terms of mitigating the harshness of the criminal law, and secondly, in influencing society and the criminal law towards the directions of more humane and more effective ways of dealing with the problem of the criminal offender.
Well, Tom, would you agree with what Bernie has said, that notwithstanding illustrations that all of us are familiar with, occasional cases, perhaps more than occasional, in which the use of psychiatry has turned out to be harmful, that by and large, the use of psychiatry in the criminal law has had the effect of mitigating harshness, and also has had the effect of giving real meaning to the individualization of criminal offenders, which is one of the important continuing developments of criminal law. Not to treat all criminal offenders in a uniform way so that everybody who commits a particular offense gets exactly the same sentence, but to treat them as individuals and to determine just how the system should respond to them. Some persons who commit homicide may be susceptible to release to society within a few years. Others may have to be kept in prison for the rest of their lives. Do you agree with Bernie's notion that individualization is desirable, or are you in favor of treating everybody uniformly regardless of individual characteristics?
Well, something in between. Let me make my position clear. I don't believe in treating everybody uniformly. I believe that it is a job for the jury, and it is a job for enlightened criminal law to make distinctions among various types of offenses, like first-degree murder, second-degree, involuntary manslaughter, and so forth. So that I believe in these distinctions. What I don't believe in, and in fact, what Bernie describes and what you have described and characterized as individualizations through psychiatry, that I consider the essence of tyranny. Tyranny is often thought of as something that's very harsh. No, to me tyranny means arbitrariness. The psychiatric intervention may be invoked or may not be invoked. A person may be released after 2 years or may be kept for 20 years. And this depends upon the judgment of experts. This, to me, is what is my model for this is the inquisitorial method, as against the accusatorial Anglo-Saxon model.
But what is your alternative?
My alternative is essentially the image expressed in the Roman symbol of justice, blindfolded, impartial, even-handed justice. Therefore, similar offenses, similar or identical penalties are meted out. And there is no psychiatric intervention at all into the judicial process. I would abolish psychiatric intervention in the judicial process altogether.
Yeah, that's again a view of a somewhat abstract and idealized criminal law in which criminal law, or society through the agency of the criminal law, deals only with deeds. And this is a very attractive and very seductive idea, so that if the deed is the killing of another human being, then the law deals with that deed and punishes accordingly. Now, I think it's very fortunate that the criminal law is not at all that arbitrary and that rigid. There exists concepts, statutory and traditional definitions of crimes, which allows a great deal of individualization of the criminal law. And I believe that the psychiatrists, as well as other behavioral scientists, sociologists, psychologists, and the like, have a lot of information which they can provide to the law, which enables or which will facilitate the law making the kind of individual decisions which it has to make. For example, the crime of killing other people is not just a simple crime. There's almost a dozen legal varieties of homicide, ranging from justifiable homicide, which is not a crime at all, through such things as misdemeanor manslaughters that may mean 2 weeks in jail, all the way up to first-degree murder, which may mean death in the gas chamber or the gallows or life imprisonment. Now, the law sets forth a great many criteria by which these distinctions are made. Now, most of these criteria are based not just on the physical events of the criminal act, but many of these criteria require very specific knowledge about the psychological attributes of the individual offender, the state of mind. And here I think the psychiatrist is often in a very special position to provide concrete information about the state of mind of the offender, which enables the jury to make a more just decision.
All right, I think that we're at a point where we understand...
Part 2 will present the conclusion of psychiatry and law. How are they related? The opinions expressed on this program do not necessarily constitute endorsement by the Department of Health, Education, and Welfare, the Public Health Service, or its constituents.